Yes, call the list.
But I got one humble prayer.
Yes,
But I feel that these two matters are fit to be hard today. 47 and 48. You will also take it up on Thursday.
Thursday. Who is appearing for the opposite
But I
party?
will inform.
Okay.
47 and 48.
রাখুন আমি পরে অর্ডার করে দেবো এর নোটটা রেখে দিন I will pass the necessary order. Thursday you are Thursday means 18th.
18.
One humble prayer in respect of item 90.
Please allow me to work
Definitely.
first. Just
Hello,
wait.
one registration application, madam, inclusion in the list.
Have you served?
No,
Have
madam.
you served?
Yes, madam. Copies are madam. To the
Okay. Reason after vacation reason. But you know, I will restore your application subject to my satisfaction that there is merit. So you have to assist me on
Yes.
the merit of the case.
Yes.
There will be no adjournment. First restoration, then disposal. It won't work. I will restore and dispose it off on merit.
In respect of item 90, this matter relates to discharge. The criminal revision application is against the discharge. So I have to inform state as well as the de facto complainant. But kindly take it up after vacation. In the meantime, I will serve
Okay.
notice on state as well
Okay,
as the
just- Aditya Babu, I had a note রেখে দিন. Anyway, item number 90 to রেখে দিন.
90,
After
90.
vacation, he is asking
Kindly
for.
take it up after vacation.
Anyway,
In the meantime, there will
let
be
us
service.
come back to item number 1.
But
Yes. Appeal is accepted. Oh, you appeared, no? Appeal is accepted. The order of conviction is set aside. He will be discharged from bail bond subject to 437A for 6 months. I don't know how it is being complied with. 437A? You don't know. No, we want to bring this provision at least to the fore. Yes, there is something like that. 437A. I don't know how it really. Yes. Call. Aditya Babu. Call.
Alright, on behalf of Mr. Devabrata, I am playing for a passover, short passover.
Yes, 3. Yes.
And I have the instruction to appear on behalf of the private opposite party.
My learned friend had earlier appeared. I gather Mr. Ronobir Rai Choudhury is there for the
Yes, for the
state.
state.
For the state, you are for the private opposite.
Private.
My
Madam, I-
learned friend has filed.
Yes,
So
absolutely.
to Jomadi Beach,
No, I did it.
my learned friend has served us with a copy of the affidavit in opposition.
Okay.
Well, we need to give a reply to that. Well, if your lordship permits us to file our reply 1 week after the vacation, and if the matter could appear 2 weeks after the vacation or something, other date your lordship. That's-
But whenever this matter is taken up, my lord will have to bear us because it is a part and matter anyways. Well, the affidavit in opposition, my lord, be kept to this record.
Well, if your lordship permits us to file a reply by 1 week after the vacation.
Very well. Mr. Ujjwal Rai, Mr. Ujjwal Rai, this time I am remembering your name. Learned
grateful
counsel
and
for,
honored, man.
for the opposite party number 2. No, again, affidavit in opposition is filed on behalf of opposite party number 2. Mr. Ujjwal Rai, learned counsel. Sorry, Ujjwal Rai reference of Mr. Ganguly, learned senior counsel representing the petitioner, submits that an opportunity may be given to the petitioner to come back with affidavit in reply.
I
He-
wait for affidavit in reply.
Yes. File affidavit in reply. Opposing the petition or affidavit submitted by private opposite party. Number 2. Let the matter is adjourned to appear on 13th of June.
Your Lordship.
Liberty is given to the petitioner to submit affidavit in reply to this affidavit in opposition filed today by 1 week after vacation, by 10th.
The difficulty is that I am not there till the 9th.
Oh,
So if it subject to your lordship's pleasure, if the hearing could take place a week thereafter and I could
Then-
file my
okay,
affidavit in reply.
then
by
you
13th.
do one thing, fix it on 20th of June for hearing, and by 13th of June.
But
Deeply
I may be served with a copy of this.
Yes, yes, of course. Should I mention it? I don't think.
Your Lordship. Your Lordship.
Deeply. Deeply.
Great. Can
Thank
take
you.
your Lordship.
এসি কি চলছে না? Yep. Leela Paul.
Rejected administrative notice. After the administrative notice was given, I have been appointed by the opposite party, private opposite party.
You
But
are
my
most
lord, I do
welcome.
not-
Yes,
But I do not have the copy of the revisional application. I have only the administrative.
you don't have the copy of the petition.
petition. So, my lord, I need that, and then my lord, I will.
Then why don't you approach Mr. Meter? Do you have, you don't have any?
My client is missing. It was also on my client. Whether that my client is alive or not, that is.
She is
Leela
alive.
Paul.
She is alive.
বুঝতে আছে? কোথায়? এরা জানে কোথায় আছে?
হ্যাঁ,
এরা বক্তৃতা বল না।
এরা কি করে দেবে শত্রু তো।
আমি তো পাচ্ছি না।
ঠিক আছে, আমি খবর দেওয়ার ব্যবস্থা করছি। অন্য
হ্যাঁ, কিন্তু তোমার জানে। My lord, I give the copy.
Yes. Huh?
My lord, different manner he will.
Very well, I don't want to even know. I am
Yes,
not
yes, my lord.
interested.
Yes, yes, that is.
I am simply adjourning the matter
My lord will adjourn.
without recording your difficulties.
Just
I'm
sincere.
posting it after vacation.
On prayer of the parties posted
Yes.
after.
Yes.
একটা কপি
Third learned counsel for the parties. Oh. Both of whom are seeking accommodation. Let the matter be adjourned to appear on 15th of June.
My lord, 15th, 20th,
20th. Very well. 20th of June.
obliged.
Nikki, Passover matter. Item number 2. Yes. What's the outcome of your research?
My lord, the outcome of my research is one judgment of the Supreme Court. আমি বুঝিয়ে দিচ্ছি আমাকে, আমি আমারটাই দিয়ে দেবো আপনাকে, আমার কপিটা দিই। কোনটাতে? এটা হলো my lord, state of Andhra Pradesh versus Bhaktidiram Reddy and others. Kindly
Hmm.
comes to my lord, paragraph 10 and 11. 10 and 11. I'm reading it out. You can get it. My lord,
It's on 251.
yes. On that point, subsection 1 of section 464 of the
Hmm.
Code of Criminal Procedure 1973 expressly provides that no finding, sentence or order by a court of competent jurisdiction shall be deemed invalid merely on the ground that no charge was framed or on the ground of any error, omission or irregularity in the charge, including any misjoinder of charges, unless in the opinion of the Court of Appeal, confirmation or revision, a failure of justice has in fact emphasized been occasioned thereby. Subsection 2 of the said section lays down the procedure that the Court of Appeal, confirmation or revision has to follow in case it is of the opinion that a failure of justice has in fact been occasioned. The other section relevant for our purpose is section 465 of the code, and it lays down that no finding, sentence or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation or revision on account of any error, omission or irregularity in the proceedings unless, in the opinion of that court, a failure of justice has in fact been occasioned. It further provides inter alia that in determining whether any error, omission or irregularity in any proceeding under this court has occasioned a failure of justice, the court shall have regard to the fact whether the objection could and should have been raised at the earliest stage in the proceedings. Now, my lord, paragraph 11. This court in Williams Laney versus State of Madhya Pradesh, this is Justice Vivian versus judgment, elaborately discussed the applicability of section 535, 537 of the Code of Criminal Procedure 1898, which correspond respectively to section 464 and 465 of the code, and held that in judging a question of prejudice as of guilt, courts must act with a broad vision and look to the substance and not to technicalities, and their main concern should be to see whether the accused had a fair trial or not, whether he knew what he was being tried for, whether the main facts sought to be established against him were explained to him fairly and clearly, and whether he was given a full and fair chance to defend himself. Viewed in the context of the above observation of this court, we are unable to hold that the accused persons were in any way prejudiced due to the errors and omissions in the charges pointed out by Mr. Arunachalam. Apart from the fact that this point was not agitated in either of the courts below, from the fact that the material prosecution witnesses who narrated the entire incident were cross-examined at length from all possible angles, and the suggestions that were put forward to the eyewitness, we are fully satisfied that the accused persons were not in any way prejudiced in their defense. While on this point, we may also mention that in their examination under section 313 of the code, the accused persons were specifically told of their having been committed an offense under section 114. This is my submission before your lordship. In this case, my lord, this squarely fall under in this situation. That is all is my submission.
Mr. Roy.
My lord, other day, my lord, I have submitted in this particular case, as far as this judgment is concerned, the guideline is all time is there. But my lord, in particular case, your lordship will find nothing has been spelled out as regards my acquisition in the 251 proceedings or the order passed under section 251. Here, my lord, my lord, all that has been stated that there may be ambiguity of the acquisition, there may be some parts of the acquisition has not been properly spelled out. But in my case, my lord, nothing has been spelled out.
No, you are not suffering any order of conviction. You are not suffering any order of conviction.
No.
According to you, nothing was spelled out to your client. So why not subsection 2 and send it back to learned trial court?
My lord, to that.
Now, this time, whatever deficiencies,
My lord, now, my lord,
they can have the chance to plug the holes.
then, my lord, the other thing, my lord, I would like to agitate today. My lord, that is, my lord, 326 subsection 3
CRPC.
CRPC.
326 subsection 3.
Yes. It was never a summary trial.
But it is a summary trial.
It is a summary
summons
trial,
was
but
clear.
it was never followed.
According
Again, if you say that, it's a valid ground to send it back and to direct the magistrate to follow 260,
My
but
lord,
for all practical purposes,
my-
it is
My
not
lord,
possible.
my lord, according to the statutory prescription,
Hmm.
it should be a summary trial.
No, it should be a summary trial provided there can be a departure subject to certain observation.
But
by
that
learned
observation must be reflected in the order itself.
Yes. So this is again an informative
And
for
now,
which
my lord, now I am reverting back to the age of the case.
My lord,
But the age of the
No.
case.
had I been tell you lose this
my lord,
cannot.
in our case,
Yes.
my lord, in our case, the recording of the plea, the learned magistrate who held the plea did not record the substance of it. That is the only technicalities that was wrong. But otherwise, in the order, it was clearly mentioned that it was read over to him. The offenses of 138 and after listening to he says Nirdosh. My learned friend wrote a judgment on the previous day. There also it was written it can be curable. Now, if 313 he had argued He had never taken that objection at the earliest stage also.
Don't look back to that. We have come across that
Yes,
provision. We
sir.
have had a detailed
So, my lord,
discussion.
I
Come to subsection 2 of section 260,
260.
268.
260.
260.
By necessary implication, learned magistrate invoke the provision of subsection 2 of section 260.
260 surplus 2,
My lord,
summary trials,
Hmm.
surplus 2. When in the course of a summary trial, it appears to the magistrate that the nature of the case is such that it is undesirable to try it summarily, the magistrate shall recall any witness who may have been examined and proceed to rehear the case in the manner provided by this code. My lord,
So it is
uh,
always open to learned magistrate
My lord.
to adopt some other means. According to you, there was no such
order is
explicit.
there.
so this is
Yes,
the summons procedure.
There must be no reflection.
fine. This is again another technical defect you are highlighting. Let it be cured by learned trial court.
My lord, now, my lord, coupled with, my lord, I am an acquitted accused.
No, that is why I cannot convert it. I don't want to convert it to a judgment of conviction. Let it be decided afresh by learned trial court.
My lord,
Only point, this man was denied the benefit of provision of 138 is that he failed to prove there was existing liability to pay the debt, according to you. Now, my interpretation is the moment you issued the check, admittedly,
my lord, the
presumption is you have issued the check in discharge of your liability. Now, how far you have been able to discharge the same? That is the question. You are highlighting towards the source of the man to accommodate you with such a huge sum.
and my lord, not only that, his own averment and my lord, his own deposition before the court that he acquired money by selling 3 vehicles. It is his evidence.
In some of the judgments, Honorable Supreme Court said, yes, it is important. In
And-
most of the judgments, Honorable Supreme Court says, no, don't look for the source.
But
Let
one of
him
the
rebut.
recent trend, my lord, one of the recent trend of the honorable court was something different. But I have placed one judgment and on the other day I mentioned this judgment, my lord.
Then
This is 2019, volume 5 Supreme Court cases, page 514,
Basalingappa.
Basalingappa.
now you were referring to
And my lord, very recent,
paragraph.
my lord, paragraph,
Is it,
my lord.
this you have downloaded from India Council?
Yes, my lord, that is.
Anyway, I just give me the citation.
2019 volume 5 SCC, page number is
418,
418
418.
SCC,
It's,
Okay.
19 volume 5.
my lord,
There
here,
are- My lord, there are other judgments also.
Yes,
which-
yes, I have come across.
my lord,
After Rohit Bhai J. Patel's judgment, which I had referred, the complainant needs nothing to prove, only the check if admitted by the accused that it is my check, I have signed it. The presumption, the legal presumption in this case, not
My lord,
factual presumption,
my lord,
that starts.
my lord, law of precedent, judicial discipline, Supreme
No,
Court
whether-
reiterated time and again.
It has, whether that judgment has been taken into consideration by the.
I think
apex
my
court.
learned judgment is subsequent one.
My Rohit Bhai judgment, my lord, these are just 15 days difference.
Yours is latest one,
No, I think my learned friend's judgment was passed later.
letter, without taking into
No,
consideration.
without taking into consideration Rohit Bhai J. Patel. That is called incurium.
Then we need to fall back on the factual aspect of both the cases.
Both.
But after Basalingappa's case in 2019, 2021 and 22,
One of the very recent Supreme Court said, my lord, so
Where
far
is
the
the-
date is concerned, on the date of, my lord, the presentation of check, what was the actual amount, that is the amount considered. Not that the check
Oh, that
amount.
is there in the Basalingappa's case also, in this case also, and
My lord,
heavy
nowadays,
exports. Suppose, my lord, that what my elephant is saying, suppose I give a check of rupees 5 lakhs. And the date on that day found to be 4,67,000. Then in that case, that.
No, to that effect, I have pronounced one judgment
Yes.
dismissing the petition of complaint. There was no existing legal debt to
Yeah,
that
That is,
extent.
that is
Well,
not in our case.
my lord, that judgment you're talking.
Yes, that,
is not there in
that
our
was
case.
given in the light of section 56 of the NIR.
Yes.
My lord, here in this case, my lord, your lordship. Your lordship.
Now, I will, Mr. Roy, I will go through this judgment
But
between the
here,
lines.
my lord, particular paragraph, my lord, your
If you
lordship.
come to paragraph 18, the law is reiterated. I need to go through
Applying the
between the
definition
lines.
of the word proof in section 3 of the Evidence Act.
No, I'm referring to 18, 1-8.
18 of.
Oh, my lord,
18 of the judgment you have referred to.
my lord.
No, no. It is 4.
18. A three judges bench, my lord. The three judges bench of this court in Rangappa versus Sri Mohan, 2010, volume 11, Supreme Court cases 441 has occasion to elaborately consider the provisions of section 138. In the above case, trial court had acquitted the accused in a case relating to a dishonor of check under section 138. The honorable court has reversed the judgment of trial court convicting the accused. In the above case, the accused has admitted signature of the check. This court held that where the fact of signature on the check is acknowledged, a presumption has to be raised that the check pertain to a legally enforceable debt or liability. However, this presumption is of a rebuttable nature, and the onus is then on the accused to raise a probable defense. In paragraph 13 following has been laid. The High Court in the order noted that in the course of a trial proceedings, the accused has admitted the signature of the impugned check dated such and such was indeed his own. Once this fact has been acknowledged, section 139 of the Act mandates a presumption that the check pertains to a legally enforceable debt or liability. This presumption is of a rebuttable nature, and the onus is of the accused to raise a probable defense. With regard to the present facts, High Court found that the defense raised by the accused was not probable. But here, in this case also, whether my defense which has been raised was a probable one, and that has been considered in this judgment. Here also, that the date was
What are the relevant paragraphs?
paragraphs, my lord, your lordship kindly come to paragraph 25. Here certain things has been formulated.
25.
Here, my lord, paragraph 23.
No evidence was laid by accused.
Now, your lordship kindly see. We have, my lord, last, it is the
We having noticed the
we have
ratio.
been noticed a ratio laid down by this court in above case under section 108A and 139. We now summarize the principles enumerated by this court in the following manner. Once the execution of a check is admitted under section 139 of the Act mandates a presumption that the check was for a discharge of the debt or other liability. The presumption under section 139 is a rebuttable presumption, and the onus is on the accused raises a probable defense. The standard of proof for rebutting the presumption is that preponderance of probability. To rebut the presumption, it is open for the accused to rely on the evidence led by him, or accused can also rely on the materials submitted by the complainant in order to raise a probable defense. Inference of preponderance of probability can be drawn not only from the materials brought on the record by the parties, but also by reference to the circumstances upon which they rely. That it is not necessary for the accused to come to his witness box in support of his defense. Section 139 imposes a evidentiary burden and not a presumptive burden. It is not necessary for the accused to come to a witness box and support this. But applying the proposition of law as noted above, in fact, of the present case, it is clear signature on the check having been admitted, a presumption shall be raised under section 139 that check was issued in discharge of the debt or liability. The question to have looked into is as to whether the probable defense raised by the accused in cross-examination of PW1, when the specific question was put that the check is issued in relation to a loan of rupees such and such taken by the accused, the PW1 said he does not remember. PW1 in his evidence admitted that he retired in 1997, on which date he received money benefit of rupees 8 lakh, which was encashed by the complainant. It was also brought to the evidence that in the year 2010, the complainant entered into a sale agreement for which he paid amount of rupees 4,50,000 to Bolana Gowda towards the sale consideration. Payment of 4,50,000 being admitted in the year 2010 and further payment of loan of 50,000 with regard to which complaint number 119 of 2010 was filed by the complainant, copy of which complaint was also filed exhibit T2. There was burden on the complainant to prove his financial capacity. It was year 2010-11, as per own case of the complainant, he made payment of rupees 18 lakhs during his cross-examination when financial capacity to pay 6 lakhs to the accused was questioned. There was no satisfactory reply given by the complainant. The evidence on record thus is a probable defense on behalf of the accused, which shifted the burden on the complainant to prove his financial capacity and other facts. There was another evidence on record, that is the copy of the plaint of such and such filed by the complainant for recovery of loan of rupees 7 lakh given to one Balaram Gowda in December 2009. Thus, there was evidence on record to indicate that in December 2009, he gave rupees 7 lakhs in sale agreement. In 2010, he made payment of rupees 4,50,000 towards the sale consideration, and further he gave a loan of 50,000 for which complaint was filed in the year 2012 for further loan of rupees 6 lakhs in November 2011. Thus, during the period from 2009 to November 2011, amount of rupees 18 lakhs were given by the complainant to different persons, including the accused, which put a heavy burden to prove financial capacity when it was questioned on behalf of the accused. The accused, being a retired employee of State Transport Corporation who retired in 1997, and total retirement benefit which was encashed is rupees 8 lakh. The High Court observed that though the complainant is retired employee, the accused did not even suggest that the pension is the only means of survival of the complainant. Following observations were made in paragraph 16 of the judgment of the High Court. Though the complainant is retired employee, the accused did not even suggest that the pension is the only means of survival of the complainant. Unless there are these circumstances, the trial court finds that the complainant failed to discharge his initial burden to prove the lending capacity is perverse. There was one aspect of the matter which also needs to be noticed in the complaint filed by the complainant, as well as the examination chief of the complainant has not mentioned as on which date the loan of rupees, here also no date has been mentioned.
Yes.
Identical issue was dealt with by the Apex Court. Paragraph 26, 28, and 31. And here 29 probably, paragraph thus there is a contradiction in what was the initial
Now,
state of.
Mr. Roy,
Madam,
come to the cross-examination of your client.
madam.
My ex-wife said that she will take care of the matter. Had there been no such loan, what's the point of taking care of the matter?
Admittedly, from the complaint itself.
You have to take a
Paragraph
stand.
4 of the complaint, your lordship kindly have a look.
You have to take a stand. Either no loan was taken or loan was taken by your wife, not by you, so you don't have any liability. Which one is correct?
But the second one is correct.
Loan was taken by your wife, you had no liability. So we can proceed with that proposition.
So far as my approach in the court below is like this. I cannot deviate from that. And this is the case of the complainant himself.
Now, if that be the case, when check has been issued by you, the law is that you have extended your shoulder to take the burden. There are judgments of Honorable Apex Court on behalf of company. One of the directors from his personal account issued a check. This question came up. Honorable Apex Court said no. When he has issued the check,
He is the liable. He is liable. But yeah,
in your case also comes to this, boils down to same thing.
It is neither the case of the defense nor the case of the prosecution that he stood as a guarantor.
that will show from the document he has supplied. He has produced. But one thing,
No, we are.
but one thing, my lord, your lordship kindly come to the very inception. A case was started against two persons. According to the learned trial court, that the prosecution was dropped in respect of person, though his application for discharge was refused. And according to the order, she was also faced the plea. And
So again,
thereafter,
you are digging out something justifying an order of remand. So let me discuss everything, point out the lacunae committed by the learned trial court and give it a second thought.
but there I join issue, but it is a case incident of.
No, had I been tell you, look, that cannot be your stand. You have to select either of the two.
My lord, one more thing, my lord, I just found out.
And thirdly, my lord,
P. Russia versus Abdul Nazir, which is passed by the Supreme Court of India, 12th August 2020.
Bring out.
Source not required.
No, bring out.
Well, I'll in the course of this time.
the third thing, my lord, your lordship kindly consider, but this is a settled law. So far as the exercise of your lordship's power under appeal in a case where the person has been acquitted.
In a case where the person has been acquitted. Yes.
But the power are equal.
Hmm.
I'm not on that.
Hmm.
But the only one of the caution and rider which can be availed by the person who has already been acquitted.
No. If it is found that the judgment is perverse, it can be converted. If it is not perverse, but there is certain lacunae, it can be remitted back. So what's the harm? If you don't allow me to reverse the judgment from acquittal to conviction, let it be decided by learned trial court.
Ample materials, my lord, for
You have taken contradictory plea. Your first case is that man did not have the capacity to lend the money. And your second stand is, it was not me, my wife took the loan and he promised me to take care of that. Which justifies the capability of the man.
We are reparting back. These caused only for non-explanation of the plea as required under section 251.
Again,
That's why
it is back to square one.
that's why, my lord, the respondent, my client, now beat at the bush. He once approach this way, once approach that way.
Fine.
My lord,
Don't take clear 251. Give us sufficient notice that what is happening.
my lord, so far as this case is concerned, your lordship, kindly visualize. The person who lodged the complaint specifically came with a story or a complaint that he gave loan to X.
So your stand is, it was X who is liable, not me,
Me.
the Y. That is your case?
My lord. And my lord, in order to, my lord, justify this, my lord, to
No, then it
go
will
into
be,
the root.
then it will be a case of approbate and reprobate. If you say this man had the capability, but he did not give the money to me, but to my wife.
No,
Sometimes
my lord.
what happens,
But-
I'll
but
tell you
two
about
things-
this, sometimes
Well,
it's made.
two approach was made. First of all, my lord, one thing, it is not me. I have loan was given to the person who is facing trial, and secondly, the person who is claiming that he gave loan has no capacity. Your lordship can look into this.
Then what about my wife said, I will take care of that? What about that statement?
One thing, what happens, my lord, suppose two persons comes and asks for loan, A and B. Acha, I'll give you the loan. And I give it in the hand of B. To whom did you give the loan? I gave the loan to B. Actually given to both of them. You give it to him, I will. Like that, sometimes they say, my lord,
That
people
problem,
say in complaint that I gave it to the wife. Actually
that
giving
is
to
not
the-
an issue the moment check was issued.
My lord,
The moment check was issued, he has embraced the liability. So that is not the point.
my lord, the fact remains, admittedly, there is a dispute and difference between the husband and wife.
Where is the document divorce? It was
No,
never
no.
filed.
But-
It was never filed before the learned trial court. Who knows? At all there was divorce, or it's a paper document to get rid of these things. Who knows?
But that was not,
Thing is that.
that was not challenge also.
Yes,
What is
that was not challenged, but now it
There
is
a
coming
piece
to
of
the
evidence
before-
where he gave the house to his wife.
That is
But
before.
he
Daughter.
said- Daughter, but and the daughters are staying with the wife. He stays in that house, wife and daughter stays somewhere else because we served him that address only he received.
My
the
lord,
next
so
day.
far as the capability part, my lord, your lordship will see that how, so far as the capability part, falsity, my lord, how the person
But you
has
have
to-
admitted.
hatched up another false story.
No, you have admitted. Otherwise, what's the point? My ex-wife said that she would take care of the matter.
Because she has taken loan.
So that is what I'm
If
telling.
if
Take
at all,
take
if at all, my lord, subject to
And
No,
he
if
does
at
not,
all-
deal with the complainant as a
You
as a
have to take
security.
you
Then
have
I've
to
taken the
take
loan,
a
I'll give the money.
consistent stand. Loan was not taken by me, my wife.
not
Fine.
by me, my lord, it is there, my lord.
Then
I have taken
then-
loan, my lord, it is, my lord, these categorical, my lord.
then why are you taking that stand? This man did not have the capacity.
But there is a faint approach, but not in that way that I was she was compelled to, my lord, issue the check. But that was not properly,
She did not issue the check. Check was issued by you.
the husband was compelled to issue the check under duress. There is faint approach, but that
Judas
is
maybe from the wife.
not
from
the complaint, by the complainant, by the
Not from
complainant.
complainant.
by the complainant.
Was it in the form of permanent alimony?
But my lord, so far as my lord, the approach, very,
Now, Mr. Purokayesto wants to come back with the latest judgment of Apex Court. 2022.
22. RP Russia versus Abdul Nasir. 2022, that course is not.
my lord, in this particular issue, divergence opinion is there.
So,
But my lord,
Let us concentrate on
What has
facts
fallen
only.
from my lordship, lordship is absolutely correct. This type of evidence are laid to show that he did not have the source to give that money, to revert on thing that he might not have paid the money because he doesn't have the source. But here, if we admit that my wife took the loan, I did not take the loan, then that means he has given the loan. So now the question of source is absolutely a misnomer. Becomes a
my
misnomer.
lord, if that be so, here, my lord, they have admitted, my lord, it is, your lordship will find, it has been admitted that the loan of rupees 10,000 was taken. Not that I have not taken anything,
You have
10,000.
taken 20,000.
But 20,000. And
You have
and
taken 20,000 and your wife took 8,40,000. Sum total 8,60,000. Check was issued equivalent to that amount.
Malad, so far as the 8 lakhs and all things, Malad, that is one different thing. I cannot substantiate that.
No, you
But
said
Malad,
your
he has-
wife.
But
your
he has
wife
no
from it.
capacity to Malad, give that loan. Therefore, question of debt. But my liability is to Malad raise the question or Malad the bio
My lord,
preponderance of probability, whether he was at all able.
Don't any reasonable doubt or proof that they both took the loan, 3,000 আমার কাছে বাকিটা ওনাকে।
But admittedly, I took loan.
That is, my lord,
And I repaid that also I have stated in my evidence.
Show it.
But
Show it. You repaid.
Malad,
Your check was bounced. No more on this, Mr. Roy. Let us move to some other matter.
this is a case Malad, where not an probable Malad, the evidence has been
No, no.
adduced.
I was not with Mr. Purokayasto since day one because it was somehow came to my notice that the loan was taken by the wife and it was the wife. But when I find that yes, check was issued not only by you, you took the plea that my wife misused the check. Then you have to discharge your owners to make a probable defense.
Malad, so far as 313 your lordship will turn.
Huh? You are not happy with that? Which is why I'm saying that let me,
Malad, so far as 313 your lordship kindly.
Yes.
Question number, second question, Malad,
at page
at page Malad 16.
16. Question number 2.
Malad. So jumble question,
Compound, yes,
jumble question.
this should not
And
be,
when for it also, Malad, everything will go.
no, everything will not go. Then again, 464 is there. I can send it back on remand, highlighting, what would happen.
Malad, your lordship,
এটাকে একটু বন্ধ করুন তো অনলাইন স্ট্রিমিংটা
Malad, your lordship
put it
kindly.
up.
Malad,
Hmm.
Malad, your lordship kindly.
Question, page
16,
16.
Malad.
that is the only thing we can say.
Yes. The complaint in this case is filed, this case, the complaint, I don't know whether it is correct or not. Against you alleging that you gave him one check of the amount of rupees 8,60,000 in discharge of liability, which was bounced owing to insufficient funds. Thereafter, a demand notice was sent. It should have been placed separately. I have never given any check in discharge of liability. You are not saying that check was not issued by me, not in discharge of liability. So,
he
After discharge of any
cannot
liability.
deny because
He has
admit-
only denied that I
he
did not
never
discharge.
denied that it was not my signature. He has not denied. Therefore,
now he has to raise a probable defense. Now he is running parallelly. On the one hand, he is saying that this man did not have the capacity to extend loan. So no money was taken. On the other hand, he is saying it was not me, my wife, and he told me, my ex-wife told me he would take care of this.
but Manoj, the one
So what boils down? It negates your stand that the man was not capable of accommodating
Manoj, subject
loan.
to
And he has taken
Manoj, subject
20,000
to your
minus
lordship.
Yes,
taxes.
yes.
Manoj,
But he has
Manoj,
taken
subject to your
20,000
lordship.
rupees.
Manoj, judicial scrutiny and Manoj, your lordship's Manoj, experience in this field. Manoj, the question which was put to me,
No, not happy. I am not happy with the
and the
way.
question was pinpointed to the acquisition of this person only and only. But this is not the complainant case.
No.
But what is failing from your lordship?
Learned trial court need not confine himself to the case of the complainant during examination under section 313. The factor that should weigh the learned magistrate is the evidence that would be used against him.
But Manoj,
Attention is to be drawn to the notice of the accused person, to the evidence, incriminating evidence, which could have been used against him to give him an opportunity to explain the incriminating circumstances.
Manoj, assuming Manoj, that is the consideration and that was required.
That
to
is
be
the law
consideration.
subject to
That is the
correction.
law.
Yes.
That is the law. But Manoj, so far as the case of the complainant, it is also from the evidence that the loan was given to the lady concerned.
Absolutely
And
right.
also to the man also, 20,000.
And
he took.
Manoj,
No. Absolutely right. The loan was given to the lady concerned. So you were admitting that man had the capacity to accommodate loan, which was not extended to you but to your wife.
Manoj,
Part to him, 20,000 to him.
there I join issue.
Yes.
Complainant case is this. Manoj, here how the question starts. Manoj,
313.
330.
Yes, I am with you. I am not happy the manner he was examined.
And my lord, so far as the
But how it will help you, Mr. Roy?
Manoj, only one thing we can help my Manoj, so if I am saddled with the requirement of section 138, that part I can say there was no existing debt or liability to be discharged in my favor.
But section 139 doesn't say so. It says the person who issued the check owes the liability.
And my lord, coupled with my lord, the rebuttable
Yes,
presumption.
you have to make out a probable defense.
Then in
Now you have two defense. One is that this man did not have the capacity. Second one is it was not me, my wife who took the loan. So this is mutually contradictory. The moment you say money was taken by my wife, you were supporting the case of the complainant that there was accommodation of loan.
But if
And your defense goes.
my lord, if we want to turn around, my lord, if the person has no capacity to give loan,
Then you would have said,
They-
no, it's rubbish. He did not have the capacity to extend loan. So no question. My wife did not take. I also did not take any loan. Matter comes to an end.
And then FIR in the police station that the check was lost.
that
Whatever it is. Once you admit that it's not me, my wife, you were supporting the case of the complainant that yes, I gave loan.
my lord,
Now comes
my lord,
the
the accused of the state, my lord, statement of a co-accused will be taken given credence.
no. Who is the co-accused?
But the other accused proceedings has
She is
been
not.
dropped.
Yes,
dropped. He has not been acquitted.
Dropped, filed for the present. I don't know how it was. The case was not handled very satisfactorily. There is no doubt about
But
it.
if it is dropped and your lordship wanted to,
No, no, if you want to get the matter cured, I am ready. I will send it back indicating how it should be read into evidence and direct the learned magistrate to completely
But
enter
that-
procedure
that-
and come back.
that- but that would be, Malad, your lordship can revert back then to Malad section 251 stage.
Huh?
And coupled with
Then
the-
I know, I will take note of that. The learned counsel for the opposite petitioner, you are the Opposite party. Huh.
Respondent.
submits that 464 will take care of the way 251 was considered by
And-
learned magistrate.
313 exactly that question was put, so that he is getting
But
enough.
he is to be examined under section 313, no way out. In proper manner.
Well, not only that, but also Malad, the section 326 subsection 3. That also Malad attracts there.
By necessary implication,
But,
260 subsection 2 was invoked.
But
Though there is no specific order. Mr. Roy, how many cases you have been dealing of this nature?
but
138?
so far
Did
as
you ever find one that was
6 months.
conducted under section 260?
But I am very much poor in 138 matter. In fact, this is the,
You take information, you just go, but collect data from Bankshal Court nearby.
Huh.
Not a single case 260 CRPC was ever invoked by learned trial court.
and Malad,
No,
one
no,
thing,
members at the bar won't allow. That is the whole difficulty.
and Malad, one thing is troubling me.
Once you file a petition of complaint, unless it runs for at least 5 years. No, don't.
But I have gone through the book and the provisions of the statute, wherefrom it is mandate that 6 months. Or it can be extended, but the extension cannot be years
No.
together. Here, your lordship,
No, section 260 was never invoked. It was conducted under the summons procedure case.
Summons procedure. That is what I'm saying.
So by necessary implication, subsection 2 of section 260 CRPC was invoked by learned trial court. That would be the answer to your non-compliance of subsection 3 of section 326 CRPC.
If it had been tried summarily, you would have been deprived, Mr. And you not
No,
given any
Malad,
opportunity. I would have gone away, walk away with 139.
Malad,
Presumption.
deprivation or not deprivation, it is
Anyway,
the, it
There
is
is
the
really, Mr. Roy,
legislature to look into.
Mr. Roy, I don't think there is.
Yeah, I have
anything left.
wasted your lordship's more valuable time, Malad, that I know.
There is
But
nothing
Malad,
left.
this is a case which is troubling me. But how, but I do not, so far as my knowledge in 138 Malad, I candid Malad very poor. Hardly.
No, it's all in statute, book of statute. And you were supposed to know the law better than anybody. else.
No, Malad, so
At
this
least-
law, I am very much poor.
The
Malad, because I am not, I do not know the
erudite persons on the other side.
practical aspect of this, the provision. But when it appears, so far as the proceedings in this particular case I read, there it appears there is a small, there is every possibility of false implication. And your lordship knows, nowadays it has come out that issuance of check by way of guarantee or issuance of check
No,
by
no.
collateral security, issue of check is the main.
No, you make it in black and white. The purpose of issuing check. No problem.
That is only what is the requirement. That purpose was not for legally enforceable debt or liability, but for some other purpose.
It's a security check. Matter comes to an end.
Security,
My lord.
not all security check, or not all security. Security check, my lord, is under the purview of one thing.
My lord,
Or premium or charity.
Well, so far as the consideration by the apex court or our court and all everywhere, it is for that purpose that the person who is holding the check will be the beneficiary.
Yes.
No doubt about it. But there are instances,
No.
And my lord, the legislature very aptly,
You have come across so many cases where civil dispute has been given the flavor of criminal offense. There are many.
many.
So,
And my lord, your
so
lordship,
that is in one way misuse of the
and
provision.
your lordship also knows,
For that 482 is there.
but that, and your lordship also
Thank
knows,
you.
in a case
Uh,
the Supreme Court held, since you have not initiated any criminal prosecution, your civil liability also good. Because there are two different aspects in commercial transaction and all this.
So we are calling it a day. So for this case is concerned, tomorrow you will be giving me the judgment.
In the course of this day. I
In
will
the
submit
course
to
of
court
this day,
officer.
better. I will
I
start.
will,
dictating.
I'll give a copy to the court officer
Yes.
in the course of this day.
Heard Mr. Puro Kayesto, learned counsel for the petitioner, and Mr. Devobroto Rai, learned counsel for the opposite party number 2. Stop. Hearing concluded, judgment reserved.
I'm grateful, my lord.
If possible, before vacation, if not, immediately after reopening.
I'm grateful, my lord. Grateful.
Only make it a point to give the judge. Yes, yes.
I'll supply. The citation I'm like to get. Apni patent meeting. See Russia versus Abdul Nasser. 2020. August 2020. P. Russia versus Abdul Nasser.
Then for it to document.
I'm grateful, my lord. Grateful.
PW item number 3, 5 হলো 3 হলো then 4. No, 6 onwards. এটা কি ব্যাপার? হ্যাঁ।
Question item number
45.
6 to 45.
Yes, sir.
I am appearing led by Mrs. Aparna Banerjee for the Provident Fund order, which is.
Fine.
Some instruction is required in this matter.
Don't give me that. I have been adjourning the matter since.
Lordship,
See,
petitioner is also not there, Lordship. Kindly adjourn, just take it after vacation, Lordship. We will do it.
since 5th of April, the matter is being adjourned. 5th, 25th, then 3rd of May. Today it was fixed as suggested by.
16th May. Lordship, just give me a last chance, Lordship. Petitioner is also not.
Yes, Mr. Gupta was there for the petition.
Sure, I don't.
Kaushik Gupta, hey, Aditya. Kaushik Gupta, কোথায় গো? This matter was fixed at his behest on 3rd of May.
Lordship, shall I call him?
Please
Just make it short, possible.
call him, indicating that the court is not in a mood to adjourn the matter.
Lordship, I.
কোনটা? আচ্ছা 57, 58, 59 কি হয়েছে? না এটা হঠাৎ এখন কল ও এখন কল করে দেবেন, করে দিন একবার সবটা। হ্যাঁ ঠিক আছে। তারপরে করে দেখ। হুম 47, 48 শেখর বাসু না, কবে বললেন? থার্সডে। একটু নিয়ে নিন both item number 46, 47. (46, 47) or 47, 48? (47, 48), yes. learned, Mr. Shekhar Basu, learned senior counsel, is seeking an accommodation. Let the matter be listed on 18th of May, 18th of May 2023 under the same heading. ব্যাস ওইটুকুই করুন। এগুলো হয়ে গেলে জাজমেন্টের ডিক্টেশন দেবো, অসুবিধা হবে আপনার? যেটা শুনলাম, হ্যাঁ দিয়ে দেবো, ঠিক আছে। একটা কাজ করি আপনার সাথে, দেন
Complete status report has not been sent.
why in part?
My lord, they have not received, my lord. It has been done.
Well, not this week. You ensure the complete report. Call the list.
One. Three. Four. Five. Seven. 8. 9. 70. 71. 5. 9. 8.
What? After vacation? Why? Before vacation you had difficulty, even after vacation? It appeared earlier also. Anyway, I'm not fixing it, but not this week. In the meantime, you come prepared. These old matters, let us get rid of this. After vacation, make it a point. Not this week, করে রাখুন. So automatically it will come after vacation. Why? You are for the petitioner? দেখি 103টা দিন, 103টা দিন। Yes, what's the outcome?
So I had a talk with Mr.
Yes.
He has not come today. He told me that his client is more than 72 years old. He has contacted, but client has sent no instruction to him. He is also seeking for adjournment. Kindly make it not this week. It's up.
আদিত্য ওই লম্বা যে লিস্ট আছে না, then I am not passing any order. Item number 6 to 45. After vacation, not this week করে দিন, তাহলে পরে ওটা হয়ে যাবে। But Mr. Day, on the adjourned date, let's clear the desk. Unnecessarily, nothing is in the matter. देखिए item number 103 টা দিন তো। তারপর আমাকে ফাইলটা দিন, আমি জাজমেন্টে ডিক্টেট করি, that would be better. And then not this week করে দিন। Yes. Record the presence, then তাহলে লিখে নিন তো
On the prayer.
6 to 45 on the prayer of Mr. Amajit De. He always submits in installment. Learned advocate for the petitioner.
Lordship,
The matter
opposite
is-
party number 2.
Opposite party number 2. Sorry, learned advocate for the opposite party number 2. The matters are adjourned to appear on
After vacation, immediately.
after slumber on 8th. Appear on 8th of June under the same heading. Yes, Mr. Panda, what is there? You have challenged, you are. There was no order of stay. Somojit Das Mahapatra for the petitioner. একটু নিয়ে নিন না। This revisional application challenges the proceeding in GR case number 501 of 2008 arising out of Shivuri Police Station case number 164 of 2008 dated 14th of August 2008. One 156 tree. Briefly stated, Sri Shopan Kumar Bose, proprietor of Modern Enterprise, filed a petition of complaint before the learned Chief Judicial Magistrate Birbhum against the accused persons, alleging inter alia that the complainant placed 4 vehicles on hire to the accused person for the use of the accused person, and an agreement was executed by and between the parties on 1st of October 2004. Stop. It was clearly spelled out that the accused person would pay a sum of rupees 90,300 per month to the complainant, and after 2 years he would return the vehicles. But the complainant did not pay the higher charges and deserted the vehicles in a very bad shape. Stop. The information since disclosed ingredient of offense cognizable in nature, learned Chief Judicial Magistrate forwarded the petition of complaint to the jurisdictional police station, and Shivuri PS case number 164 of 2008 was registered. Stop. Sujit Agarwal, the accused person, filed this application under consideration. Stop. Mr. Panda, learned counsel for the petitioner, with all fairness submits that the petition was admitted on 20th July 2011, but no order of stay was granted. As a result, police submitted charge sheet and the trial perhaps has been commenced. It has commenced. You don't know. Yes. Police submitted charge sheet as it now. Okay. Then who is ready to lend the name? Yes. What is your good name? Shubham Bhagat. Okay. তাহলে Mr. Panda বাদ দিয়ে Mr. Bhagat করে দিন। Yes. From the order dated 9th of December 2016, it appears that charge sheet has already has been submitted against the petitioner, and there is every reason to presume that our trial has commenced during last 7 years. Stop. Therefore, I am not inclined to invoke the provision of section 482 of the Code of Criminal Procedure. This revisional application has practically become infructuous and is dismissed. Okay, disposed of. Disposed of. How does it matter? Just tell me. To your client. No, in whose mind? In whose mind it comes? Mind of your client. That is what I'm saying.
Actually, it sounds otherwise.
Huh? হচ্ছে অসুবিধা হচ্ছে বল কোনো প্রবলেম নেই কিছু আচ্ছা এই এবারে আমাকে এটা দিন তো রিভিশনাল অ্যাপ্লিকেশন হ্যাঁ 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 সাপ্লিমেন্টারি কল করে
My lord,
Yes.
is on his excess 1429. Can it be taken up at 12, my lord?
12th of June,
No, my lord, 12 o'clock, my lord, today.
12 o'clock. Yes. Ask him to come.
Wait.
I mean, আমাকে একটু এটা দিন যা রিভিশনটা যেটা শুনলাম না এই যে এখন শুনলাম দেবব্রত রায় আর পুরকাশ অ্যাপিল হ্যাঁ কোথায় দিয়ে দিন করে দিন অ্যাপিল ওনাকে ডাকুন পেপার বুকটা দিয়ে দিন আর এলসিআরটা দিন this criminal appeal challenges the judgment passed by learned 9th Court of Judicial Magistrate, Alipur, 24 Pagana South, in connection with the complaint case number C 2532 of 2003, comma, corresponding to tier number 730 of 2003. Stop. By the impugned judgment, learned trial court recorded an order of acquittal in a proceeding under section 138 of the NI Act. Stop. Para. Mr. Shatarup Purokayesto, learned counsel for the appellant, assailing the impugned judgment, submits that learned trial court failed to appreciate the evidence on record in its proper perspective, and the judgment is the outcome of absolute misreading of evidence. Stop. It is contended by Mr. Purokayesto that the appellant filed the petition of complaint under section 138 of the NI Act as Sri Shomen De and Srimati Paramita De failed to as Shomen De and Paramita De, comma, who took a sum of rupees 8,60,000, comma, issued a check video number 612517 dated 2nd of January 2003, drawn on State Bank of India, Esplanade branch. The check was issued by Shomen De, the husband, on behalf of his wife Paramita De, in discharge of their liability to repay the loan. Stop. The check was presented to the State Bank of Hyderabad, comma, Sharad Bose Road branch, but returned dishonored for insufficient fund. Stop. Statutory notice was given to the drawer of the check under section 138 of the NI Act, but the requisition of notice was not adhered to. Stop. Hence, the petition of complaint was filed. Para, the complainant adduced evidence as PW1 and he stood the test of cross-examination. In course of cross-examination, he produced 3 documents admitted as Exhibit A, B, and C. Stop. Those 3 documents substantiate the claim of the complainant that a sum of rupees 8,60,000 was taken by the accused persons from time to time by executing those 3 documents. Stop. As the check was not honored by the bank, stop, bank, comma, and the drawer of the check failed to pay the money equivalent to the check amount, comma, there is a presumption that the check was issued in discharge of the liability incurred by the drawer of the check, comma, though the loan was taken by both the husband and wife. Stop. The drawer of the check had the obligation to rebut the presumption of section 139 of the NI Act by making out a probable defense. The drawer of the check Showman Day adduced evidence as DW1. He has admitted the signature appearing on the check Exhibit 2. During cross-examination, he stated that he did not give any reply to the statutory notice issued by Deepak Kumar Shah, the complainant, as he had no liability to repay the amount in the alleged check. Stop. His ex-wife told him that she would take care of the matter. Stop. According to Mr. Purokasto, learned trial court ought to have considered that the accused person, Showman Day, failed to discharge his onus to rebut the presumption as laid down under section 139 of the NI Act. Stop. Learned trial court ought to have recorded an order of conviction. Stop. Para. Tearing asunder, tearing, T-E-A-R-I-N-G, tearing ASU and DER asunder the contention of Mr. Purokasto, Mr. Debobroto Roy, learned counsel, for the respondent. Number 2, submits that learned trial court did not examine the accused persons properly in the light of section 251 of the Code of Criminal Procedure. Stop. According to Mr. Roy, the acquisition of offense was never read over and explained to the accused person, and thus he was seriously prejudiced. Stop. The accused person stood the trial without being informed about the acquisition of offense. Stop. My attention is drawn to the order dated 24th of August 2011, which runs as follows: : inverted comma to likhe din. Both sides are present. Full stop. Accused likhchen uni ACCDS are examine in. Don't go by correct English. Examine in under section U/S 251 CRPC. Stop. Punishable offense under section 138 NI Act. Stop. No, NI Act. তারপর ক্যাপিটালে শুরু হচ্ছে the contents of plea read over and explained to the accused মানে ACCD are in Bengali, which he pleaded not guilty by saying নির্দোষ, এটা বাংলায় লেখা আছে নির্দোষ, and claims to be trial. Full stop. Fix 14/11/11 for evidence. Unquote. It is further submitted that a proceeding under section 138 of the NI Act is to be conducted under section 260 of the Code of Criminal Procedure. Stop. Learned trial court did not follow the procedure as laid down under the Code of Criminal Procedure. Under the Code of Criminal Procedure, sorry. According to Mr. Roy, learned trial court was justified in recording an order of acquittal for the simple reason that the complainant failed to establish that he had sufficient fund to give a sum of rupees 8,60,000 to the accused person. Stop. As he failed to prove the source of money, adverse presumption should be drawn up against the complainant, and learned trial court was absolutely justified in passing the order judgment impugn. To buttress his point, Mr. Roy places his reliance upon the judgment pronounced by upon the judgment of Honorable Apex Court pronounced in Bashalingappa, BASA, Basa, LINGAPPA, Lingappa versus Mudi Basappa, MUDI BASAPPA, reported in 2019 within bracket 5 beyond SCC 418. I have produced the evidence on record. I have produced the evidence on record as well as the proceeding as well as the order sheets of learned trial court. It is the specific case of the complainant that he lent money to the wife of accused person, Paromita De, as well as to the accused Showman De. And in discharge of such liability, Showman De issued the check bearing number 612517. Stop. This fact stands admitted. Stop. When it is admitted by Showman De that the check was issued by him, comma, it is to be presumed that he has issued the check in order to repay the loan incurred by him and his wife. Stop. The onus was shifted upon the drawer of the check to rebut such presumption. Stop. In his bid to discharge his onus, Showman De, the respondent number 2, took two specific defense. Stop. According to the respondent, the money was never received by him as loan other than a sum of rupees 20,000. Stop. The loan was taken by his wife, and during subsistence of their marriage, his wife told him that she would take care of the loan. Stop. The other defense of the accused person is that the complainant did not have the capacity to extend a sum of rupees 8,60,000 as a loan. Stop. This two stands of accused person, in my humble opinion, appears to be mutually contradictory. Stop. If the loan is taken by his wife and his wife assured him that she would take care of the issue of repayment of loan, comma, it indicates that the complainant had the capacity to accommodate the accused person or his wife and to pay a sum of rupees 8,60,000 towards loan, comma, as claimed by the complainant. Stop. Therefore, in my humble opinion, the accused person failed to raise a probable defense to rebut the presumption of section 139 of the Code of Criminal Laws. 139 of the NI Act, sorry, NI Act. Stop. According to Mr. Roy, the accused person was not even examined under section 313 of the Code of Criminal Procedure. And for that reason also, he was prejudiced. Stop. He did not have the opportunity to explain the incriminating circumstances. Para. Though Mr. পুরো কাজ তো আচ্ছা দরকার নেই it is বলে দিয়েছিল এই একটু এটাকে বন্ধ করে দিন তো ছেলেটি আছে না সুইচ অফ para true it or 150. What is that? Oh. देखिए 50 की है RPUP. Yes,
279 and 304A.
279, 304A. Yesterday the matter appeared.
1 month and 6 months.
Fine.
Yesterday.
Do you have the deposition with you?
I have the deposition, but I do not have a photocopy of
You don't need to keep this with you. Give it to me.
it. But Malad,
Yes,
kindly forgives me, I have certain marking.
Okay, doesn't matter. It was road traffic accident.
Road traffic accident. 9 witnesses were examined.
Yes.
The complainant has not been examined by the investigating officer.
Forget it. For 1 year back, the accident took place near Joydev Poddaboti petrol pump. I found one constable expired on spot. As per instruction of police, I put my signature. How? Two. I do not know anything. Declared hostile. 3,
But
4.
all the scissor list witnesses were declared hostile.
2 years back, one LP truck dashed one police in front of Poddaboti petrol pump at Joydev Mode. Driver fled away, leaving the said vehicle. I cannot recollect the number of the truck. Police came and seized the truck under proper scissor list. I put my signature. Yeah. At the time of accident, I was on duty at petrol pump. The distance from PO to petrol pump is 10 feet. The pump is on the northern side of the highway. Highway road is busy. The said police person was proceeding towards the southern side from northern side. On the high road, on the side of high road, there are 2 yellow lines demarcated for walking. There was no traffic on the high road. After 2-3 minutes from accident, I arrived at the PO. After 2-3 minutes from accident, I arrived at the PO. Fine. PW5, NBA Hossain and Homeguard were on duty near the one truck loaded with stone proceeding towards Ilambaya with high speed and ran over NV of Nur Hossain. We stopped. Was sent to Shivri Hospital for his treatment. After pulling him under the side truck, I did not see the driver. I went to Sadhu. We were proceeding by police. We cannot recollect myself were checking the vehicle. The highway road was very busy on the relevant red light, green light was not used. In the highway, there is no traffic zebra crossing. However, the driver sat inside the event. We're checking the road, the distance between Jeep and the place we were standing 10 hands. I cannot say specifically how much speed should be maintained. I was never interrogated by IO. Fact that on the highway there is yellow line on both sides of the between road. Wish.
PW9 is the owner.
IO was not examined very well. What's the reason? Why this order of conviction was recorded? What's the reason? What's the logic? Why this conviction was recorded by learned trial court?
On the basis of the witnesses, the magistrate has relied upon 1, 2, 4, 5, 6, 7, 8, and 9. And my lord, all the magistrate has treated them as eyewitnesses.
Learned defense counsel, eye of the case and
My lord,
mechanical
get it from
experts
page
have
number.
not been examined. Fine. How for non-examination of IU in favor of defense, I am to find out it is fact that 20 witnesses or 9 witnesses considered. Most of the witnesses
Madam,
are
page number
eyewitnesses and their
17,
evidence
your
is
lordship will find.
sufficient corroborating apart from this, if this is not a case of defense. Yes, আসুন এটা করে ফেলি. Who is for the state? You are for the state.
My lord, I am led by Mr. Navanil.
Mr. De.
My lord.
Right. Yes. What is your good name?
My lord, Rajeshwar Chakraborty.
Rajeshwar Chakraborty. Okay. This revisional application challenges the judgment passed by learned additional sessions judge, second court Shuri at Birbhum, affirming thereby the judgment and order dated 29th January 2010 passed by learned judicial magistrate at Dubrajpur, thereby recording an order of conviction under section 279/304A of the IPC and thereby sentencing the accused person to undergo simple imprisonment for 6 months and to pay fine of rupees 500 for committing the offense under section 304A of the IPC and to suffer simple imprisonment for 1 month for committing the offense under section 279 of the IPC. Para, briefly stated, on 3rd of January 2007, SI Ajoy Sarkar of Dubrajpur Police Station informed the officer in charge of the police station that on 3rd of January 2007 at about 19:15 hours, while he, along with force, were performing duty on Panagarh Morgram Highway near Joydev Padmavati service station at Joydev More within the police station of Ilam Bazar. Joydev More, Joydev More, a truck registered as WB 41 capital A/8177 dashed NVF 1934 Mohammad Noor Hussain. He was taken to hospital where he succumbed to injuries. Stop. The information since disclosed offense cognizable in nature, Dubrajpur PS case number 1 of 2007 dated 3rd of January 2007 was registered under section 279/304A of the IPC. Stop. Police took up investigation and submitted charge sheet against uh, Akbar Ali. Stop. Accused Akbar Ali stood the trial by pleading his innocence. Stop. In order to crown success, prosecution examined as many as 9 witnesses. Stop. Learned trial court, after considering the evidence laid by prosecution witnesses, recorded the order of conviction. Stop. The accused person made an unsuccessful attempt to reverse the order of conviction by preferring criminal appeal number 8 of 2010. Stop. Learned additional sessions judge, second court Shuri, was pleased to dismiss the appeal and thereby affirmed the order of conviction. Stop. Para. I have heard Mr. Chakraborty, learned counsel for the appellant, and Mr. Miss. And either of the two, you want your name recorded? Shima Bishwas and Miss Shima Bishwas, learned counsel for the state. Stop. It is submitted by Mr. Chakraborty that learned trial court failed to appreciate the evidence adduced by prosecution witnesses in its proper perspective. Stop. No evidence came to the fore indicating that the driver of the offending vehicle was responsible for the accident, and because of his rash and negligent manner of driving, the victim sustained injury. Stop. It is further contended that prosecution since failed to examine the offending vehicle by mechanical expert, the possibility of accident due to mechanical fault cannot be ruled out, but learned trial court and learned appellate court did not consider this aspect of the prosecution case. Stop. Miss Bishwas, learned counsel for the state, however, submits that all the 9 witnesses claimed to have the knowledge, direct knowledge about the accident, and learned trial court was justified in recording order of conviction based on the testimony of eyewitnesses, which was rightly affirmed by learned appellate court. Stop. Para. I have the benefit to go through the testimony of prosecution witnesses as certified copy of the same has been made available by learned defense counsel. Stop. Ajay Sarkar is the de facto complainant who set the criminal proceeding into motion, and as PW1, he stated that one truck bearing number WB 41 capital A hyphen 8177 dashed and ran over NVF Mohammad Noor Hossain while it was overtaking another vehicle. The truck was at a high speed. The accident caused due to rash and negligent act of driving of the accused person. Noor Hossain was taken to hospital where he succumbed to injuries. During cross-examination, he stated that the road was highway and busy. He, along with the injured, the distance from Joydev Mode to Padmavati service station is less than half kilometer. The truck was standing at a distance of 100 feet from the place of occurrence. He was confronted with the written information, Exhibit 1, and he admitted that he did not mention in the written information that the accident took place while the offending vehicle was overtaking another vehicle. Stop. PW2, Arafat Khan, comma, PW3, Abu Tahir Khan, PW Abu Tahir Khan did not support the prosecution case, did not support the prosecution case, and both were examined in the light of section 154 of the Evidence Act. PW আচ্ছা আমি PW4 বললাম না আপনাকে কি বললাম বলুন তো এটা হচ্ছে PW2 PW3 ওকে PW4 Ghaffar Khan stated that an accident took place in front of Padmavati petrol pump at Joydev Mode. The driver fled away, leaving the said vehicle. He arrived at the place of occurrence after 2-3 minutes from the accident. PW5 Constable Gurudas Mondal stated that one truck loaded with stone while proceeding towards Ilam Bazar at a high speed ran over Noor Hossain. It was a very busy highway. He himself, along with NVF, were checking the vehicles on the highway at the relevant point of time. Stop. PW6 Vishwanath Choudhury is an employee of Joydev Padmavati service station who stated that hearing a sound, he came out from the station and found a police personnel who was lying with injuries. PW7 Boshanto Bagdi the copy of judgment be sent down to learned trial court for information and necessary action. Photocopy of the testimony of prosecution witnesses be kept with the record or is taken on record, whatever. You have to prepare a photocopy and submit it in course of the day. কি আপনিও চিফের ঘরে আছেন কি? আপনি কোথায় আছেন? চিফের কাছে। ওই একই একটা হার্ড কপি করে একটা সফট কপি আমার পিএ কে দিয়ে দেবেন, যদি কিছু চেঞ্জ করতে হয় আমি বললাম।
My lord, in this matter, I am appearing for the state. My lord, I am running from court number 42.
Thank you. You are appearing, but nothing will be taken on record. None is appearing for the state.
My lord, in this we are.
Now everyone is watching, you know what is going on.
My lord,
It's live streaming, Mr. Agarwal, please. Consider the dignity of the institution also. Now we are on live streaming. Please don't do this. Yes, call the list. Where is
Yes,
Mr. Mukherjee? Call Mr. Mukherjee. Yes, again, what is your narrative? Mr. Mukherjee was there a few minutes back.
Another matter has been called upstairs, my lord, in 551. Mr. Mukherjee is on his legs now.
So we have 25 minutes to go.
Technically, yes. my lord.
If you wish, I am waiting for Mr. Mukherjee. Only 25 minutes.
My lord, it could be taken up.
ওরা not today করে রাখুন। আর কি আছে? ঠিক আছে, রঞ্জিত কর। সব ডাকা হয়ে গেছে, লিস্ট শেষ। আপনি করে হার্ড কপি for the day. Why?
Second of April, that has been fixed after vacation. I don't have any other.
Who has given you that order?
No. Just I am saying, my lord. The reason, my lord. I have some matters.
Oh, you are free for the day, rest of the day. You go.
I am.
State is omniscient, omnipotent, and omnipresent. So it hardly matters. Thank you.
But at the very outset, I state that I missed it. It may extend to 10 years. But I've checked it, may extend to 10 years. 7 was awarded, 7 years were awarded. I have served already 5 years. So my lord,
Minimum
10
punishment,
not less than 10 years.
No, not seven.
not less than 7 years,
7 years.
pre-amended.
Yes, ma'am.
So we are helpless. We have to go by the statutory
Yes,
provision.
but my lord,
Yes.
let me be granted the remissions as per the jail code.
No, that is always available to you, subject to 428.
If your lordship then that.
Oh, very well, I will note it down. I will note it down, don't worry. আর একটা ক্রিমিনাল অ্যাপিল আছে, ডিক্টেশন দিয়ে দেবো? হ্যাঁ বলুন। হ্যাঁ নেবেন নেবেন, অসুবিধা কিছু না। এটা দেবো? Mr. Bhattacharya, do you have any matter?
For the next one, I have concluded my argument, well, that CBI matter, the measurement issue where the measurement was not done. Charge of forgery failed, but 417 I was concluded.
Where is
Kollol Mondol.
yes,
Well, it will be marked as part hard in that case.
no, it is parted.
So, subject.
There is no such weather forecast, don't worry.
Because I don't have any protection, well, so I'm. We'll come back subject to my lord's convenience.
So on when should I fix it? It's almost hard. There is hardly 8th of June.
Hopefully on that day, Mr. Mondol will conclude this hearing.
এটা একটু আইটেম নাম্বার কত বলুন তো?
And the next one, I guess.
8 তারিখ আপনি করে দেবেন, কোনো অর্ডার দরকার? ঠিক আছে,
Obliged to lordship. Well, may I take your lordship's leave?
yes, thank you. LC একটা দিন, এই এটা বন্ধ করে দিন, এটা পক্সো অ্যাক্ট